Hello, this is Matt on the Moon Family Sedan channel. Attorney John Deaton is under attack yet again in a legal brief which was just filed, and this time it's actually not the SEC that's doing the attacking. It's the plaintiff in another XRP-related case that was filed before the SEC v. Ripple lawsuit all the way back in, I believe it was November of 2018. And in this particular suit, the plaintiffs are claiming all sorts of things, and they're looking for a ruling for XRP to literally be declared that, XRP is a security. And recently, and I covered this at the Times within the last few weeks or so, Attorney John Deaton jumped into that case as well, and I'm thankful that he has. He's seeking to jump in as amicus, just like he did in the SEC v. Ripple case, just like he did in the SEC v. Library case. He was successful on both fronts there. He's seeking to play the role as amicus yet again, this time in the Zakhanov versus Ripple lawsuit. And the plaintiff on the Zakhanov side, they ain't having it. But what's interesting, you'll see as we go through this, they're not so great at arguing against why Deaton shouldn't be able to participate as amicus. Rather, what they do, a lot of what they argue anyway, it's just personal attacks against him and the parties that he's representing. And there's another part, and I can't wait to share this with you. It's so rich. The plaintiff here, kid you not, they state, and I'll show you the exact words, but they're arguing that Attorney Deaton, he shouldn't be allowed to be amicus in the case because it doesn't make any sense, and there's not been a case made as to why he should be able to represent so many XRP holders. And I'm just sitting here thinking, you damn crackheads, do you know what you wrote? Because in the Zakhanov case, the Zakhanov lawyer that just said that about Attorney Deaton has been arguing that they should be able to represent every single XRP holder, including you and me. I'm like, you whiny damn crackhead, what are you even talking about? So I'm going to go ahead and break it down. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And by the way, I did print this thing up. Got some dead trees up in my little Moon Family Sedan fingers here, and I highlighted the parts that I found most interesting. It did make a few notes here. But first, let's quickly set the table because I want to make sure that we're all caught up to speed here. Just a few weeks ago, this article was launched on Bitcoins.com. It's titled, XRP Lawyer Deaton Files Amicus to Join Another Ripple Lawsuit. The U.S. Securities and Exchange Commission lawsuit against Ripple Labs is not the only battle the company is currently fighting. In fact, there is a court case that has been under trial for a longer period of time. The class action lawsuit filed by XRP investors against Ripple Labs and CEO Brad Garlinghouse, which has been pending since November of 2018. The case, which is being heard in the U.S. state of California, is led by plaintiff Bradley Sostak, with three lawsuits, which would be Zakhanov, O'Connor, and Greenwald, consolidated into one. The plaintiffs accuse Ripple of selling XRP as an unregistered security and seek damages for losses suffered from the sale and alleged promises by Ripple. In addition, the plaintiffs are asking the court to also classify XRP as a security. So it's very clear that this would be an extreme minority of the XRP community. Almost nobody who has ever held XRP for any amount of time thinks what they're arguing is remotely reasonable, yet they want to represent all XRP holders. And then Deaton jumps in. Think about the audacity here, because on the side of Zakhanov, because Deaton jumps in here and he's like, yeah, well, representing closer to like 76,000 XRP holders, and they actually push back against that argument, which is insane in and of itself. And they're like, well, who are you to represent all these XRP holders? Oh my God. Well, then who are you Zakhanov lawyer crackheads? It don't make no damn sense. So there was this by Attorney Fine. This is from February 6th. He tweeted out, John Deaton will be filing a motion to file an amicus brief in Zakhanov v. Ripple in California. There, the plaintiffs claim that Ripple sold XRP as non-registered securities. He was kind of setting the table there. Now, XRP community member and attorney Fred Rispoli responded to that, also on February 6th, and he wrote, and this is interesting, being familiar with class actions, the class certification battle is the most important fight in these types of cases. John coming in here in this capacity is a real kick in the balls to plaintiff's counsel. And I don't disagree with John, but the ball kick cannot be overstated. And to which Jeremy Hogan actually responded to that, and he wrote LOL. It's on your screen there. So it's a funny way to word it, fine. But apparently this is actually something when you're trying to assert a class, because we're talking about a class action lawsuit, the Zakhanov v. Ripple case. Kind of hard to do that when a wrench is thrown in the works like this, and I'm happy to see it. So then we got this shout out and credit to Attorney Filan for sharing this, and of course, not surprisingly, Attorney John Deaton's crypto law organization also shared this actual document. So I want to give credit to Filan for doing that too, which I'll get into in just a second here. But I wanted to share with you a few tweets here, including this one from Attorney John Deaton. He wrote, "Sounds like these plaintiff lawyers have a lot in common with the SEC lawyers. What did I say when the SEC attacked me? When they can't attack the message, they attack the messenger." Now, folks, that is spot on. That's just sage wisdom for life in general. And how many times did the SEC personally attack Deaton? A lot. I don't know what the number is. Many times. How many times did it help them? 0. It helped the SEC 0 times. Now you see the plaintiffs here in the Zakhanov case doing the same thing. What a bunch of nonsense. And then somebody did ask if Deaton owns Ripple, shares of Ripple, the company, as well as XRP, which is stated in this document. And the answer is yes, as he cites on the screen here. And that's not secret information. John Deaton has been publicly stating that for some time. The reason that he even got charging down this path is because he publicly stated from the beginning he's an XRP holder himself. So when the SEC filed the suit against Ripple and then they were effectively harming all XRP holders and claiming that XRP itself is a security, he rightfully got enraged and furious just like the rest of us. That's why he moved forward. And now these plaintiffs are trying to play it off like, see, it's just for personal gain. What in the ever-loving hell? It's just infuriating, you know? And then Attorney Deaton in a separate tweet also wrote, "I guess I'm not getting a Christmas card from these attorneys either." Yeah, you're not, Deaton. Attorney Deaton, they are not going to be sending that. And then additionally, an XRP community member goes by the name Roger Ruru wrote, "This is quite disgusting. I guess me and the other thousands that signed notarized affidavits don't exist, and John Deaton made all of us up." Yeah, and so and you'll see as we go through again, I'll show you the specifics in just a second here. They take issue with Attorney Deaton even claiming that he's representing close to 76,000 people, and they don't address the fact that it was literally, if memory serves, close to 3,000 of those people notarized affidavits, so sworn statements. Talking about, well, a number of things. I haven't seen all of it firsthand, of course, but just stating things like why they purchased XRP in the first place, because it goes against what the SEC has been asserting in that case. So the plaintiffs here, which are allegedly, as they stated, they seek to represent all XRP holders in this class action. Apparently, if you feel differently, they don't want to represent you, even though you're in the majority, actually. Almost everybody that has ever held XRP at any point in time realizes how stupid this is. So let's get into some of the specifics now. And this thing was only 10 pages. And then with the signatures on the last page, and then the front page being what it is, it wasn't that much to go through, actually. But there are some parts that I found very interesting, which I'd like to share with you right now. So let's talk about this first. Reads as follows. Amici's proposed brief offers nothing unique or relevant. Instead, it simply rehashes arguments that defendants have already made and raises factual and merit issues that have no place at class certification. This is not an appropriate function for AMICUS. Oh, is that right, you little damn crackhead bitches? Well, I'll tell you what, the SEC said the same damn thing in the SEC v. Ripple case, and the judge absolutely didn't buy that. And you'll see, and this is a common refrain throughout this thing, and I'm only highlighting a few of the most interesting pieces here, but they continue to just hammer on this point, this idea, which is nonsense, that, it's just a spewing of, it's something that Ripple could already argue themselves and stuff. I'm like, hell no, it's not. Absolutely it's not. It's from additional parties that have a completely different perspective than Ripple and absolutely can argue completely different points. Just like Spin the Bits. That was, there's so many here. But the idea that it's more of the same arguments that Ripple's putting out, absolutely it's not. This is stuff coming from the perspective of people who have an actual stake in the long-term viability of XRP, but for reasons unrelated to anything having to do with Ripple. And here, these people are lying to try and get it to the point where the judge falls for them. Maybe the judge does fall for it. I sure as hell hope not. But absolutely, that's a bogus argument. And I'll just go further for additional go. And then they wrote, in addition, the proposed amicus brief is substantively and procedurally improper. The Amici are no friends of the court. Instead, they are friends and family members of Amici's counsel John E. Deaton, a self-proclaimed XRP enthusiast and public personality on social media. So pause right there. You can see what they're doing here, all right? Self-proclaimed XRP enthusiast, public personality. He has no business being here. He's just some personality out there that wants to talk about stuff and get people all jazzed up, right? That's all he's doing here. Do you see how they're framing this? This is when Attorney Deaton was right when he said this. When they can't attack the message, they attack the messenger and hope that the judge is stupid enough to think that's a good argument. As if that had any relevance, as far as whether or not the people that he seeks to represent here in this case deserve to be here. That's not relevant. Jesus Christ. And then anyway, they continue. Mr. Deaton is not a disinterested party, but rather has publicly stated that he is a Ripple investor that bought shares of Ripple in November 2020. The proposed Amici that he claims to represent include his girlfriend and current employee, his daughter, a former employee, and that employee's immediate family. Folks, to get something rolling like this, what the hell does any of that matter? They're trying to point it out like it's just a small collective of just his personal posse, but who else would ever possibly have that perspective, right? What idea are they trying to plant in the judge's mind? And is the judge actually going to fall for this? But you can see the tone and the way that they're writing what the desired intent is, right? That part is obvious. And then they write, Mr. Deaton also falsely states, this is interesting, check this out. Mr. Deaton also falsely states that he and Amici represent 75,890 XRP holders, presumably referring to an email list Mr. Deaton collected online through his solicitation of class plaintiffs for a potential lawsuit against the Securities and Exchange Commission. Mr. Deaton's false claims of representing a putative class of 75,890 XRP holders also misrepresent the court's order in the related SEC action. So again, folks, clearly an attacking of the messenger here. It's also undeniably the case that many people have signed up to be represented by Attorney Deaton. In fact, all of the names, as far as I know, you can actually see them themselves, unless memory is deceiving me. I remember seeing a big-ass list of names that are included here. This is the first time I've seen anybody deny that this exists. Like, that sounds crazy. Unless it's because they're making some sort of technical assertion that I'm not picking up. Like, for instance, are they citing that there's something about the term putative class that I as a lawyer wouldn't pick up on? Maybe. But if they're doing that and it's a technicality when they know full well that close to 76,000 humans signed up to be represented by, given that they know that is quite obvious, for them to assert something like that, it's just misleading and disingenuous. So even if there's some sort of technical reason that I'm unaware of because I'm not an attorney, fine. But it's undeniably the case that John Deaton represents an enormous number of XRP holders who think that the people here, in this case, the Zakhanov case, the attorneys representing people, they're completely off their rockers. Undeniably the case. Really grinds my gears, folks. Where my biscuits all been in this marriage? All right, let me scroll down to page 2. One sec here. So at the bottom, I wanted to cover this part too, starting right here. The proposed amicus brief is unnecessary, useless, and irrelevant. Look, are we sure the SEC didn't write this for them? Did they just copy and paste something from the SEC? It just sounds like the SEC trash over and over again. Anyway, then it says, rather than adding a unique perspective to the issues actually relevant to class certification, The proposed amicus brief reiterates arguments already made by defendants' competent and seasoned counsel and attempts to inject merits issues that have no bearing on class certification. This is improper. Okay, so false. Deaton seeks to bring the perspective of parties whose ideas are not represented here. They're just outright, it's just, again, it goes back to the question of, but will the judge fall for it? It's always the case, right? That's what I noticed again and again and again, is I've been having covered the SEC v. Ripple case for over 2 damn years at this point. Seeing the BS arguments, it's amazing, because I've never filed a case in my life this closely, so I didn't understand the degree to which, at least in the SEC's case, a party would be willing to consistently throw crap at the judge, nonsense arguments, and just hope that it sticks. I was not prepared quite for that. Certainly not operating in good faith. And so it's just interesting. You know, the same arguments, again, they're right here as well. Now let me scroll down to, I think page 6. Yeah, 1 second here. Scroll on down. All right, now, right here. Okay, the motion. I will start right here where I highlighted. The motion states that proposed amici represent the interests of 75,890 XRP holders, which the motion describes as a known putative class. Indeed, the motion purports to be made on behalf of such putative class, but neither the motion nor the related proposed brief describe in anything other than vague terms who these XRP holders are, what authority or conduct gives the 6 proposed amici the ability to represent these unnamed XRP holders, or what possible basis proposed amici have for describing these unnamed XRP holders as a putative class. Now, folks, that is what I was referencing at the outset of the video. Now, that is rich. That is truly rich. Pot calling kettle black. I mean, look, you know, it's so rich given the lawyers in this lawsuit. Again, the lawyers themselves in this lawsuit claim to speak on behalf of all XRP holders. I think the term they keep using is similarly situated, you know, as in similarly situated to the plaintiff. So, but all XRP, that's what they're going for. So wait a minute. They can do it in the Zakhanov case, these awesome, incredible attorneys, and they shouldn't even be questioned. But attorney Deaton's can't do anything that even remotely resembles that, but on the other side? The hypocrisy! The hypocrisy! What in the ever-loving hell is this jibber-jabber? What a bunch of hoo-ha and horse-pucky. I'll not be having it, good sir. Really steams my vegetables, son. So there you go, a bunch of hypocrisy, nonsense, and we can just now, at this point, sit tight and just wait to find out if the judge is going to fall for this nonsense. I don't know what's going to happen. I never know what's going to happen. But that's what we're looking at here. Yay, disingenuous arguments from lawyers. Whatever, it is what it is, man. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.